Hello, hello. Hey guys, this is Marcin Drozdz. I'm joined with Seth Bradley today, and today we're going to be making legal interesting. We're gonna have some fun with it. If you guys haven't met Seth before, today we're going to be looking at some of the most overlooked stuff in the capital raising space, legal frameworks behind syndications and investor communications. So we brought Seth Bradley here. He's the founder of Raise Law to break this down both from like a legal and operator perspective. Now, if you don't know Seth, he's a securities attorney. He's advised on over, was it 9 billion, 10 billion in private securities and commercial real estate transactions, working with syndicators, fund managers, and capital raisers nationwide. So we're going to put Seth's contact info here below. But Seth, thanks for making the time to do this.
Absolutely, Marcin. Thanks for having me, brother. Really appreciate
Yeah.
you.
Yeah, you too. Well, we had you at the workshop a little while ago here. You guys came in full force with the full team, and
You
you
know
guys
it.
had those raise more capital hats, which I thought was really on
You
brand
got
there.
it.
Or eat, sleep, raise, repeat. There you go. So cool. So the transaction volume that you've done with real estate and private securities. I mean, have you always been a securities attorney, or like how did you get into the space?
Yeah, I've been a securities attorney since 2013.
Okay.
So that's kind of how I got into the space. And when you're a young attorney and you're learning stuff like this, whatever it is, whether it's whatever your practice is, I mean, you don't know what you're doing. Let's be honest. You don't know what you're doing. You're just kind of learning, taking everything in. But I was really lucky because I did get into the security space, the commercial real estate space, and I was exposed to all the things we're doing today: syndications, funds, raising capital. My clients at the time were doing that. I didn't quite really understand it at the time, but I was exposed to it. And eventually I said, hey, I want to do this. So I started investing passively into deals, started raising capital, started being an operator. So it was a great transition for me.
Excellent. Well, we like to have people involved with our community, with our network of people that are practitioners, not just bureaucrats. So, if you're actually operating and you're in the space and you're structuring deals, it gives you common sense, which is not very common amongst your legal peers. So, congrats on that, because
Thanks. Appreciate that. Yeah. Most attorneys are not entrepreneurial, I'll say, right?
no.
They're kind of stuck in this bubble. They're kind of stuck in, black and white. Here's what you can do. Here's what you can't do. They're going to pick out all of the possible things that you can't do and give you a reason why. Because honestly, like at big firms specifically, like you kind of have to, right? Like you're trying to run up those billable hours. I mean, that's how you get paid. It's really a conflict of interest, not an alignment of interest, we'll call it. So, but when you come from the business side like I do, and when you're raising capital like I do, then I can see it from both sides of the table, and we're here to help you get your deal done, get you raised ready, and get your deal across the finish line because we're dealing with businesses, we're dealing with raising capital in real estate. There are gray areas we've got to navigate. There's risk involved in everything that we do as entrepreneurs, but it's up to us to evaluate that risk, see it, and make a smart business decision on those risks.
Yeah. Well, so today's topic is to make syndications simplified. So I understand you got some slides for us and you're going to walk us through a little bit of that. So why don't we just turn it over to you and then we can do a Q&A at the end and kind of just go from there.
Sounds good. Let's do it. Cool. We got the slides pulled up.
Are you pulling those up or are we?
Oh, I thought I already shared them earlier. With 1 second. Sorry about the technical difficulties
No, no
there.
worries. You're a syndication attorney, not a tech guru here, so it's all good. Yeah, you're rocking and rolling now.
All right, let's do it. So, all right, let's kick it off. All right, for the next 45 minutes or so, bear with me. I'm going to do something that most attorneys can't do for you. I'm going to make the single most confusing, most expensive, most at sometimes fear-inducing part of raising capital, the legal structure, and I'm going to make it simple. That's the point, right? Syndication simplified. So by the end of this, you're going to understand what a syndication actually is. Sometimes it's a scary word. You hear syndicate, syndication, you think of gangs or something. That's the first thing that comes to your mind, right? But we're going to talk about what it actually is, and we're going to talk about when it's the right tool and when it's the wrong tool, because sometimes it's not the right tool for you. And exactly, how the pros build a legal foundation that scales. Quick housekeeping. I'm a securities attorney, but I'm not your securities attorney. Some of you folks out there, I might be, but not everyone yet. And so nothing today is legal advice, it's education. So when you go to actually structure your deal, your syndication, your fund, whatever it might be, hire legal counsel. All right. And that's what my malpractice carrier makes me say. So let's move on. All right. Real quick about me, I didn't come from money, and I think a lot of you are like that, right? Like we got caught up in this trading time for money thing. I call that the blue collar mindset, where it's just trading dollar for dollar. And I grew up thinking that's the only way to go. So I went down every trading time for money avenue possible. I went to medical school. I ended up dropping out of that because I hated it. I got my MBA. I went to law school. I worked in big law for 7 years. Um, but luckily, that pathway leaded me to this entrepreneurial journey. And I think a lot of us have led that journey where we found real estate, we found raising capital, we found businesses, and we saw the light. We saw that we don't have to trade dollar for dollar, time for money, and we saw a way to get out of that. So nowadays, I've structured north of 750 funds and syndications, closed over 9 billion in real estate in private capital transactions, represented about 3 billion or so in capital raised across my clients' partners, and a very small sliver of that myself. Worked in big law again for 7 years, so I have the big law pedigree, and that is important. I want to point that out because it's really tough in this industry to even get securities law experience unless you work at a big law firm. There aren't that many boutique securities law firms, and a lot of those law firms aren't even founded by folks that are securities attorneys or that have that big law experience. But it's really important that securities attorneys see that. They see, the big clients that are closing 100 million, $200 million deals and funds, to see how it's done and to see all of the intricate things and structures and the compliance factors that go into structuring massive deals like that. So just make sure that your attorneys that you do hire are properly vetted, and that they have the track record, just like you would check out a sponsor or a deal or something like that. Make sure that your attorneys have a track record as well. I'm also a chief legal officer for a company called TribeVest, and we do fund-to-fund setup and administration. So for you folks that want to raise capital for somebody else's deal, or if you're a lead sponsor that wants to launch a capital raising channel through fund-to-funds, TribeVest is the way to go. All right, first question. Should I do a syndication or something else? So you've got a deal, or if you got the idea for a deal, and you're stuck with this question because somewhere along the way, somebody told you that you need a syndication, or maybe you heard it on a webinar like this, or maybe you heard it on YouTube, something like that. And somebody else said, no, do a fund. Just skip straight to a fund. Or then another person might say, oh, you don't need either of those. Like, let's just do a joint venture. It's easier. It's more simple. You don't need to hire a securities attorney. And now you're frozen. Now you're clicking around. You're trying to find more information. And, that can cost you. I mean, not taking action is the single most expensive thing in your business. Not because the wrong structure costs you more money, although it can. It's expensive because while you're sitting there overthinking it, the deal passes you by and it's gone, right? So the investor moved on, the window closed, need to take action. So that's the name of the game in this entrepreneurial capital raising business. Take action. So today, I'm going to take the overthinking off the table, and we're going to focus on the workhorse, I call it, of this entire industry, the syndication. What it is, when to use it, when not to use it, and how to run it compliantly. So let's start with the absolute foundation. What is a syndication in plain English? Forget the legalese. A syndication is really just a group of people pooling their money together, as well as skill sets that are getting pulled together to buy a single asset. So here's how it works. You're the sponsor, you find a deal, It might be too big for you to do on your own. Let's say, for example, a 200 unit apartment complex, maybe a development project, whatever it is. You can't write the whole check yourself. So you bring in a group of money investors, they put in the capital, everybody pulls into a single entity, usually an LLC or a limited partnership, and that entity buys that one asset. You run the deal, they ride along and collect their share of the returns. Now, I want to give you a mental model here that we'll keep returning to throughout the presentation. That just keep track of this. So think of a syndication like a bus, right? You're the driver. You choose the destination. You've got your hands on the wheels. You're in control. You're responsible for getting everybody there in one piece. Your investors, they're the passengers. They bought a seat on your bus and they're trusting you to drive and they're trusting you to keep them safe and to return them or take them where they want to go. So remember that, because that relationship, passive passengers, trusting the driver to produce the return, is the precise thing the law really cares about. And it's what makes a syndication a security. And we'll come back to what that means. For now, just lock in that picture. Driver, that's you. Passengers, it's your passive investors. You're on one bus, one destination. Threshold question here. Can you get paid to bring people into deals? Because generally speaking, you are not allowed to raise capital unless you have a license. Just like I can't practice law unless I have a license, and doctors can't practice medicine unless they have a license. Same thing goes for raising capital. It's an industry. It is a licensed practice that you have to have a license to be able to do. But there are exemptions. There are exceptions to that. And that's where we basically all live. But, we can go through these, but number one, to be licensed, it's having a broker-dealer license. That's the licensed person that can actually raise capital and get paid transaction-based compensation for that. And kind of alongside of that, RIAs are a different kind of flavor, but that's who's actually licensed to be able to raise capital. They don't need an exemption. They are the licensed folks. They are the doctor. They are the lawyer, right? Another person that can raise capital, and this is an exemption, is the GP or the owner operator, the lead sponsor. This is you. If we're doing a syndication, this is you. You are the person that's going to be operating the deal. You're the active partner. You earn through the deal. And that's most of you in this room sit here. So there's an exemption for you. And sometimes that's called the issuer exemption. It's not actually a real codified exemption, but it's in the SEC kind of guidelines and how they've put out white papers and such for this. And that's where you live. So that's mainly what we're going to be talking about today. There is a third way, which is the aggregator, I call it. This is kind of your capital partner. And this is probably the most gray area because you can come into it as, let's say, a fund of funds, or you need to negotiate some sort of joint venture deal so that you actually become the GP, the operator owner with rights. But really, we're going to focus on number two today as a GP, owner operator, the issuer. All those terms are kind of interchangeable. So inside the structure, you've got these GPs who we just talked about. That's you. We've got these LPs, and we've got the entity itself. General partner, called a sponsor. You find the deal, you underwrite it, you raise the money, sign a loan personally in most cases. You execute the business plan. These are the folks that are active partners in the deal. You're the driver, and the wheel comes with responsibility as well. In the middle, you've got the LPs or the limited partners. We'll use that word freely. So we say LPs, we say limited partners. What we really mean are passive investors. If it's in an LLC structure, so a limited liability company structure, they're not really limited partners because partners implies a limited partnership, but we're in an LLC structure, but we use those interchangeably. So just keep that in mind. But they bring passive capital, and that's it. They don't have any control over the day-to-day. In exchange, they get limited liability. So their biggest downside is capped at what they invested. If the fund or the syndication or the GP gets sued, these LPs, their downside is limited to what they invested, and that's the point, right? They're protected in that manner. So their entire job is to trust that you're going to perform and do what you say you're going to do. On the right, the entity, usually a single LLC, or could be an LP, built for this one particular deal. You'll hear me call it the SynCo or the Fund Co. That entity holds one asset if it's a syndication, nothing else. You control it through the operating agreement, which is the rule book, the governing agreement for the structure. The LPs or the passive investors are the members with economic rights, but not necessarily any control rights or very limited, we'll say very limited voting rights. And we try to limit those on purpose. It's for their protection and for yours. And the beauty of it is it's siloed. So we'll talk about that. You know, when you're comparing, well, should I launch a full-fledged fund or should I do a syndication? One of the big advantages to a syndication is that it's siloed. It's protected from an asset liability standpoint. So if something goes wrong with that asset, it's limited to that syndication as opposed to a fund that holds multiple assets. Obviously, just like think about when you own multiple houses and you put them in the same LLC, if something goes wrong with one of those homes and you get sued, then it could put all of the other ones at jeopardy. Same thing applies to a fund. Now, there are certain things that we can do to try to limit that, but just keep that in mind that that's one of the major pluses for a syndication versus a fund. And that containment feature, and we'll build on that when we talk about asset protection here in a few slides. So how the sponsor actually gets paid, we'll touch on this as well. These are the three main ways that they get paid. Now, there are many other fees that we can tack on as well, but mainly and you'll see these just about in every deal, right? You'll see some sort of an upfront fee, you'll see some sort of an annual ongoing fee, and then some sort of an exit fee or an upside, right? So the upfront fee will be most of the time called an acquisition fee, the ongoing fee and asset management fee. And then on the upside, you'll hear that called different names. So that can be your carry, your carried interest, your promote, your profit split. That's kind of your success-based fee, or that's kind of your big upside. So, but you can charge lots of other fees here to get paid. Common ones are a guarantor fee. So if you're personally guaranteeing on the loan or you bring somebody that might have some extra liquidity or extra net worth that you need to get the loan, they might get this guarantee fee. So you might tack that on. If it's a development deal, you might have a construction development fee. And that's in addition to, the contractor's markup. This is for you to actually manage the contractor. Things like that. You can do a refinance fee. You can do a true exit fee. So you get paid maybe a 1% or 2% fee on the sale price. And that's also in addition to any broker fee that you might pay out. Or if you're the broker themselves, you might be double dipping. But I don't necessarily say that that's a good thing because you have to explain that to your investors. So when is a syndication the right tool? Because it's not always. And here's the four-part gut check on that. So one, you've got one deal and one asset. That's the big thing, right? If you only have one asset and you want to keep this thing siloed, then you have a specific property and ideally, it's under contract or you're ready to close it here in 60 to 90 days, depending on what your purchase agreement says. And it's not some, let's say, vague idea that you're going to go buy some apartments or you've got this buy box where you say, I'm going to buy 200 unit apartment complexes in Georgia over the next 10 years, and it's going to be leveraged at 60% or less. That's kind of a buy box, and you might put that into a fund, but we're talking about one specific asset here. Number two, you're the operator. So you're genuinely running this thing. You're signing on the debt. Again, you're the active partner. You're managing the business plan. You're executing. You're actively and actually operating. And a syndication is the wrong wrapper. And frankly, it might be illegal for you if you're not that person. Three, passive investors. You want investors to be passive, right? You don't want to bring in all these other active partners, which then we might be talking about a joint venture. You want to bring passive investors that just provide capital, don't necessarily have any voting, managerial, any rights whatsoever. And you just want to provide them with a return on their capital. So keep that structure in mind if this is what you want. And four, and this one's underrated. These are the pluses, right? I think people are like, if you would have asked me 5 years ago, are you doing more syndications or more funds? It would have certainly been more syndications. Everybody was doing one-off syndications to buy big apartment buildings. Nowadays, deals are hard to come by. They're a little tougher to find good deals. people's transactions are much slower, so they're putting together funds because they don't know when their next deal is going to be. So a lot more funds nowadays than syndications, whereas 5 years ago it was probably flipped. But I think people have forgotten kind of what are the some of the advantages of a syndication, and some of those are simplicity, asset protection, which we already talked about, and it's really the easier capital raising vehicle for someone, especially someone doing their first or second raise. It's much easier to get investors into a syndication than into a fund because they can actually see the deal, they can see the property that you're buying, they can see what they're actually investing into, as opposed to some sort of a blind pool fund or a discretionary fund where you just say, again, you tell them that buy box, I'm going to buy 200 unit apartment buildings in Georgia. Well, you don't have one yet. Okay. They have to put a lot more trust in you that you're going to find a great deal that they would be investing into. And they've already made that commitment. So there's a lot more trust involved with a fund. It's much easier to raise for a syndication than a fund, generally speaking. Again, we kind of touched on these already, but advantages of a syndication: easier to raise, clean asset protection. Again, these are siloed. You can do a new syndication, or you will do a new syndication for each property. It's a more simple compliance path. The documentation from a legal perspective is much easier. Kind of rinse and repeat if you do the same deal over and over again. So it's faster to launch as well because of that. Aligned incentives. I mean, this can apply to your fund as well, but it's much easier to kind of align your incentives from a fee standpoint with a syndication than with a fund where you're collecting, let's say, for instance, an equity under management fee. With a fund, well, you're going to collect that no matter what, right? So it doesn't really necessarily depend on the success of the fund as much as a syndication where you do an asset management fee and it's based on the gross income of the syndication as opposed to just the equity that you're holding. Real quick, so we talked about the advantages. Let's talk about the disadvantages, where operators can get hurt with a syndication. So you raise every single time, right? So you have to spin up a new syndication for each property that you do. So a syndication is one deal, one raise, one asset. And when the next deal shows up, you start the capital chase again from scratch. And you're on a clock too. We're talking about real estate or you're closing on a business and you're doing a syndication for that, you're on a clock, right? Maybe you have 60 to 90 days to close. Maybe you get an extension, what have you, but you're on a clock to close. So there's no standing pool of money just sitting there ready to deploy. And, that gets exhausting for people. Two, deal by deal grind, kind of the same thing, right? It's deal by deal. Okay, we got another deal under contract. Let's go back to the securities attorney. Let's get the documents drafted, get the exemptions filed, spin up new LLCs. It is a grind, but once you've done it a couple of times, it's rinse and repeat. And the first time is tough. The second time's easier. Third time, it's like, all right, it's the same thing over and over again. So just like anything else, it takes reps. Concentration risk for your investors, as we talked about, is one deal. Right, one asset, one deal. If that deal goes bad, they lose all their money. Right, it can happen. As opposed to a fund, and you have 10 deals, maybe one or two out of the 10 deals goes bad. Well, the other 8 or 9 might support those losses, and so it gives the investors much more diversity and less risk concentration. For personal liability, sits on you. You sign the loan, you carry the recourse on that. Operational risk, not your LPs, and this really applies for funds and for syndications, but and it's still a security. So whether you do a fund, whether you do whether you do a syndication, whether you do a fund, it's still a security. So keep that in mind. We'll talk about a joint venture structure and when you can do that and when you can't do that. But if we're doing a fund versus a syndication, still a security either way, and hard to scale linearly. That's why a lot of people start out with syndications. They get some success, they get some reps, they get some confidence in their capital raising abilities, and they say, look, I'm ready. Let's launch a $20 million fund. Let's start raising some capital and let's start, buying a lot of assets a lot quicker. So, doing it one-off, you can scale. I mean, many, many, many billion-dollar plus firms do this in this manner with just syndications and no funds. But I would say that, at some point, most folks do kind of make that switch over to a fund at some point because it's just a lot more flexible once you have the ability and the confidence to raise that kind of capital. Taking a step back, you can see syndications versus the alternatives, right? So we talked about fund. We talked about fund of funds, which a fund of fund is really just it's just a fund that you set up and then you take that capital and you invest into somebody else's fund or somebody else's syndication, thus fund of funds makes sense. Joint venture, we'll talk about that one specifically because that's kind of making that jump from joint venture to is it a joint venture or is it a syndication? And that's really important because a lot of folks out there will call it a joint venture so that they don't have to get a securities attorney, so they don't have to pay for a PPM, so they don't have to do exemption filings. But in reality, it is a security, and now you're in violation of SEC laws. And then you've also got the traditional kind of note and deed of trust route where you raise capital through a note. So, is your syndication a security? What any securities attorney is going to look at, and what you can look at too. You can save yourself a little bit of money here. Go through the Howey test. Look at this. So it's 4 steps. It's pretty easy. So this was created from a real case, a real court case. Number one, an investment of money. I'll go through it. An investment of money in a common enterprise with an expectation of profit from the efforts of others. Pretty easy. An investment of money, easy prong. Was there an investment of money or was there not? We're just going to say yes. In a common enterprise, that can be via agreement or via LLC or limited partnership. Was there a common enterprise, an agreement? Probably pretty easy to determine that. With an expectation of profit, did the person that put in money expect a return on their profit? Probably so. If they gave you money, they're probably expecting that, right? They're going to expect a return on that profit. Number 4 is really the turning point. So that's the one you really have to dive in deep and ask yourself, was that expectation or were those profits derived or will they be derived from the efforts of others? And the way that's been interpreted is completely on the efforts of others. So if somebody gives you money and they expect you to do all of the things to give them a return on capital and don't want to do anything themselves, that's the effort of others. And then that's a security. And the 4th prong is greenlit. And you need to either be a broker dealer or find an exemption to be able to raise capital. So a real joint venture, every single member has real authority. And this comes out of a court case called Williamson versus Tucker. Real authority means hands on the wheel. Talking about the bus again. Hands on the wheel. Hands on the wheel. Major decisions, access to information, actual power to remove the manager. That's a big one. Everybody's profiting from their own genuine efforts, not the efforts of others, right? So in a real JV, that Howey prong, number 4, it fails because nobody's purely relying on somebody else. So it's not a security. Beautiful. At that point, it's a joint venture. You don't need to file for an exemption because you're not under securities laws. Now, on the right side is a disguised security where you call it a JV and it's not really, right? One partner brings only money. That so-called passive investor has no real control, no voting rights, no managerial rights. They can't make decisions. They're relying entirely on you to produce the return. Well, then it's called a joint venture, and you call it a joint venture, but substantially, it's not. It's a passive investment. Prong 4 hits. It's a security. And now you've sold an unregistered security with no exemption, no disclosures, no compliance, and you could be in a lot of trouble. And there's consequences to that because it really matters. When the deal underperforms or something goes wrong, some of them, even if they're friends and family, maybe it's your uncle, maybe it's your brother-in-law, whoever it might be, their lawyer might say, "Hey, check this out. Like you can get your money back. You can sue this person." And they get rescission. They can get their money back plus interest, regardless of how the deal performed, and you personally eat that loss. Just because you called it a JV doesn't protect you. The substance always wins. And we kind of chatted about this already, but you're either registered or you're not, right? You either register this as a security, or you find an exemption. So when we say register a security, we mean we mean stocks, right? Think about stocks. Think about an IPO. Think about Elon, right? Are you Elon Musk? Are you taking a company public and registering it? Probably not. And especially when we're buying real estate, we don't have time. We don't have the money and we don't have time because you've got 90 days to close this property. So you have to find an exemption. And those exemptions to be able to raise capital for a security are the ones that you probably heard of, 506B versus 506C under Regulation D. Okay, so those are the two big ones that we need to talk about. There are others. You can go under Regulation A plus or Reg CF, but largely we're living in the Reg D 506B versus 506C 506C world. So let's talk about that. Starting with 506B, we like to call that the quiet raise. That is the country club deals that traditionally we've been able to raise capital for in the past before 2012 and the Jobs Act. You're able to raise unlimited capital. The key here, the key positive thing is that you can raise for up to 35 non-accredited but sophisticated investors. So that's the big thing. But the other big downside of that is there's no advertising or solicitation. And that means you can't go on social media and talk about your deal. You can't go to a live meetup and talk about your deal. You can't pitch your deal to random people. There's no solicitation or advertising. So, but the advantage again is that you can have up to 35 non-accredited investors. And then you have to have this pre-existing substantive relationship with these folks that end up investing with you. And to explain that a little bit more precisely, that's actually the way that you show that you didn't advertise or solicit. So the real rule is no soliciting or advertising. And then if something happens and SEC says, okay, show me that you didn't solicit or advertise. Well, you show them that you had a pre-existing substantive relationship with each one of your investors. That's how you show that you didn't do that. Another big advantage to the 506B is that investors can self-certify so that they can actually self-certify that they are sophisticated or they are accredited, and you can take their word for it. You don't have to double check that. You don't have to verify it. You can take their word for it on the surface. Versus 506C, so we call that the loud raise. Again, unlimited capital, but the big thing here is accredited investors only. So you can't bring in any non-accredited investors whatsoever, but you can advertise and solicit publicly. So you can run ads on Meta and Google. You can go to real estate meetups and talk about it. You can post all over Instagram and Facebook and LinkedIn. You can go on podcasts and pitch your deal. You can go on stage and pitch your deal. You can do whatever you want. You can talk about these deals, and you can pitch it, and you can get strangers into your deal on the spot. But they all must be accredited. And the big thing here is you also must verify that they are accredited. You must take reasonable steps to verify they're accredited. Typically, you do that through a third party. You can do it yourself. Don't recommend it. You want to take that liability and put it on someone else. So either through a letter from their CPA, their attorney, their financial advisor, or through a third-party vendor such as iCapital, formerly Parallel Markets. So who counts as accredited? Real quick, accredited investor is somebody that has 200K in income over the last 2 years with a reasonable expectation of same in the current year. And if they have a spouse or a partner, 300K. Or alternatively, they can have $1 million in net worth, excluding the equity in their primary residence. There are also other exceptions to that, or other ways to qualify as an accredited investor. Certain license holders, so such as having a Series 7, 65, or 82, automatically qualifies you as an accredited investor. There are talks that at some point in the very near future, you'll be able to take a test, not a Series 7, 65, or 82, but a accredited investor test and get qualified as an accredited investor that way without the income or the net worth requirements. Verification by exemption, talked about this a little bit, but just keep that in mind. 506B, investors can self-certify questionnaire. You'll see an investor questionnaire in your subscription documents. That's why that's there, so that those investors can say, yes, I am accredited, here's why, or no, I'm not accredited, or I am sophisticated because of this reason. That's why that's in there. You don't have to do you don't have to do a third-party verification for that. But if you do a 506C exemption, you do have to take reasonable steps to verify, typically through a third party. Some of the compliance mistakes to kill these raises general solicitation is a 506B. So if you ever see anything on social media post or podcast, and it's a 506B, you are looking at a violation in real time. You're looking at a securities compliance violation in real time. I see it all the time. It happens. There are actually folks out there, kind of like ambulance chasing attorneys that chase accidents. I've heard about attorneys actually calling some of the numbers or signing up for some of the social media ads to poke around and see like what's going on with this particular race. I've heard about that multiple times. First time I heard it, I was like, there's no way that they're doing that. And then I heard it from multiple people over the last year, at least 3 times, where they've gotten calls from attorneys, where they found out later they were attorneys, just trying to see if the raise is compliant. I don't know if these are state commissioner folks. I don't know if these are SEC folks, but they did turn out to be attorneys, or maybe they're ambulance chasing folks that are looking for a way to, find sponsors that are doing this illegally so that they can maybe reach out to those passive investors and see if there's a lawsuit involved. I'm not sure, but it's happening. So be careful out there, folks, especially when you are running ads. Code GP, we talked about that. If you're raising capital for a deal, make sure it's actually your deal. Make sure you're an active partner. Make sure you're participating. Make sure you're not just a fake code GP that's just getting paid to raise capital and that's it. And make sure you're not getting paid transaction-based compensation, meaning compensation tied to the amount that you actually raise. No real PPM or disclosures. I'll say that if you only have accredited investors, you actually don't legally need a PPM. So you don't have to give them a PPM. Highly advise against that because the PPM is there to protect you, it's there to protect the investors. You always want to have one. It's not legally required necessarily, but if you have non-accredited investors, it is legally required. You have to do it. Now, again, I would never, ever, ever go into a security or raise capital without a PPM, but just know that there is, it's not necessarily required if you're only bringing in accredited investors. Mismatched marketing. Make sure your marketing materials, your pitch decks, your one-pagers, your landing pages, your webinars, you're saying the same thing that actually shows up in your PPM and in your operating agreement. All of that should make sense. All of that should match. Make sure it all makes sense and it all matches. Everything's consistent. And taking a non-accredited and a 506C, I think that goes without saying. Don't do it. There's no exceptions to that. If you run a 506C accredited investors only, that's what it is. You can blow your exemption that way, and then you're in a lot of trouble, and you're going to lose a lot of money and perhaps scuttle your business entirely. Sloppy investor relationships. Really, you just want to make sure that you commemorate all of your communications. So that's why you want to have an investor portal. That's why you want to have a CRM. You want to make sure your emails, your phone calls, your texts, everything is all in one place. So if something does happen down the line, you can go back and say, hey, Mr. State Commissioner, I did have a substantive pre-existing relationship with this person. Look, we have all these texts, we have these emails. I sent them these educational pieces. They emailed me back. Like there was a communication log here. So if you have that to show, then they'll be like, great, and they will move on. But they will definitely kind of poke around, see what they can find, and hopefully you've been able to commemorate your communications and your relationships with your investors. Some of the things you want to make sure that your attorney's doing, right? Like you hire an attorney for a reason. You hire them to handle all of your compliance, make sure that you're not breaking the law, all those things. But you should be at least aware of what they're supposed to be doing for you, right? So, this happens a lot when you have mom and pops attorneys. I like to call them folks that are kind of general practitioners that aren't securities attorneys that say, oh, yeah, sure, I can put a PPM together for you. No problem, right? Well, make sure that you know what else they're supposed to be doing. Like, not only are they drafting the operating agreement, the PPM, the subscription agreement for you, but make sure they file your Form D. So that's your 506B or 506C exemption. Make sure they're doing your blue sky state notices and paying those fees. So that's a big one. I've had to clean up those messes many, many times over where someone said, look, I want you to do kind of an assessment of all of our past deals, make sure we're compliant. Turns out they didn't do any blue sky notices and pay any of those fees. So, what a blue sky state notice and fee is for every investor that you have in any particular state, you have to go to that state and you basically have to do what's called a blue sky notice, quick filing online, not a big deal, but you have to do it and you have to pay a fee because the states want to get paid. So you have to pay a fee to that state. It ranges anywhere from free in Florida to $1,200 in New York. I would say on average, it's on the lower end, probably $200 to $250 per state, but it has to be done. And technically, if you don't do it, it can blow your exemption in that state. So again, it blows your 506B or 506C exemption and puts you under state law instead of federal law. And that's a big problem for you. And that gets really expensive. Now, the good news is that most states don't really care. Even if you're late, you just pay a late fee. So if you haven't done it yet, just clean that up, pay that late fee, file your blue sky notice, and you're all good there. So it's typically not enforced to the maximum. Make sure you do bad actor checks on, if you're the lead sponsor and the main principal, you need to make sure that you would pass a bad actor check, right? And then anybody else in your group, so any other active partner in your group, any other principal individual you're partnering with, do a bad actor check. Do a background check. That's a big one, right? But when I say bad actor check, I mean make sure that they haven't committed fraud, intentional misconduct, or had any kind of securities violations federally or on the state level within the last 10 years. If they have, and they're named on your Form D, then that can blow your exemption too. So these are all huge landmines that can blow your exemption. And if you blow your exemption, you have to be licensed. That's the whole point. An exemption is an exemption from having a license. And if you don't have a license, you're in a lot of trouble. So again, clean records, make sure that you document everything that you do, keep track of everything. Investor portals really help you stay organized there. Documents that make it real, there's really those three main ones. The PPM, private placement memorandum, that's your risk disclosure document. So that's the long one. It might be 100 pages, it might be 150 pages, who knows? It just really depends on the asset, depends on the attorney that's drafting it, but it's mainly a risk disclosure document. So it'll talk about the business plan, it'll talk about the asset, it'll talk about you as the lead sponsor, what you've done, your business strategy, what you're buying, and all the specific risks involved in investing in this. It's supposed to be a document that an investor can read and make an informed decision on whether or not they want to and should invest in this deal with you. So that's what it's for. It's there to protect you. So on the back end, if something happens and the investor says, hey, you didn't tell me that hurricanes were a risk in Florida. Well, should have been obvious, but you still need to tell them. Just like a coffee cup at McDonald's says, hey, this is really hot. Kind of the same thing, right? Yes, of course there are hurricane risks in Florida, but did you put it on paper? Did you notify them? That's going to be in your PPM. So a judge or whoever it might be will say, okay, show me the documents. And they're going to say, show me the PPM. And you're going to be like, look, section 45, risk disclosure number 147, there it is, hurricane risks for this asset. And then they're going to be like, too bad, right? It's protection. It's protection for you. It's like an insurance policy. Operating agreement, this is really the entity's rule book. So this governs the LLC, just like it's no different from any other operating agreement that you've seen with an LLC. It defines control, voting rights, waterfalls, fees, who gets paid and when, all those things. This is really where it counts. So PPM is supposed to be actually in plain language. It rarely is. The operating agreement is going to be in legalese, and it's going to show you the exact mechanisms for how the LLC is governed. Subscription agreement is the investor contract. It binds each investor to the operating agreement, making them a part of that LLC. Real quick, the entity and asset protection stack. I think this does a better job on the next slide to show you kind of visually how it is, but you're going to have more than one LLC involved. You're going to have your syndication company, your SynCo, I like to call it, right? That would be an LLC, it could be an LP. You're going to have a manager of that entity. So I like to call that the managed co. And then above that, that could be maybe your parent entity, or that could be you as an individual. And then the asset itself is owned by that syndication company in the most simple way. I mean, there can be complications to this, but for the most part, make sure you at least have the syndication company managed by a management company, and then you sit kind of above that. And here's kind of how that looks. Here's how that looks from an LLC structure and an LP structure. You can see here The property sits at the bottom if it's a property. The Synco owns that, managed by a managed co. And then you've got your passive investors that sit over there on the left, and your general partner principals that sit over on the right. So they can be a separate membership class there. And anything above the management company is you as an individual, or maybe there's multiple managers that sit as individuals. We never know necessarily what's up there at the top. And then the LP structure is very similar. It's very similar. So you're going to have your syndication company or syndication LP owns the property. It's managed by a management company, or could actually just be managed by the general partner as well. The managed co and the general partner could be the same entity in the structure, but here I have it divided out. Either way, both of those entities are controlled by the individual principals, which are you as an individual. Kind of starting to wrap things up here, but serious investors actually expect these things. So make sure you lock them up. A real PPM. Don't just give them an operating agreement with an exhibit and a few disclosures. Do a full real PPM. Serious investors expect that. Clean structure. You should be able to describe that org structure, what it looks like, why you have it structured that way. Transparent talk on risk, disclosure of all risks. Talk about the downside. That's more of like a soft skill when you're talking to investors. Make sure you tell them, here's the things that can go wrong and why, and here's how we've covered those risks, right? Defined reporting, aligned skin in the game. They want to see investments with you as well, or necessarily maybe a fee alignment, so all your fees are aligned. And responsiveness is a big one. Always respond quickly, and don't leave people hanging. Communication is a huge thing. Don't be the guy that bugs people to death to get them to invest. As soon as they invest, they never hear from you again. Happens all the time, and investors will never invest with you again if you do that. Building a legal foundation of skills, standardize your docs. When you work with a syndication attorney, that first one might take a little bit more time. You want to get those documents dialed in, all of your waterfall, your fees, your business plan, all the things that you do. But a lot of you folks do the same thing over and over again. So once you do it once with them, the second time should be a lot easier. Standardize your docs, standardize your process, build the relationships now, even before you have a deal. Start building those relationships. Pick your lane early. Decide if you're going to do a 506B or 506C. That really comes down to your investor avatar, who you're investing or who's going to invest with you. If you have to have non-accredited investors, it's got to be a 506B. If you want to advertise, if you want to solicit, if you want to run Facebook ads, it's got to be a 506C. Just go through those scenarios and decide which way you're going to go. Get the right team, securities attorney, potentially a fund administrator, CPA before you need them, not after a problem appears. Document everything, report everything, and graduate deliberately. So master these syndications, attend these webinars, talk to Marcin, just dive head first and figure this stuff out, because it can be extremely lucrative and allow you to scale your company. And last one, run the decision. Structure picks itself here. First of all, we went through these. Is it a security? Run that Howey test. So is it a JV or is it a syndication? Figure that out. It really comes down to that fourth prong. Operator versus aggregator. Are you raising capital and that's it? Or are you the operator? One deal or many? If it's one deal, one off at a time, syndication. If it's many, we're talking about a fund, putting it in the same security. And then how will you raise? So 506B versus 506C, accredited investors or not. Do you want to solicit and advertise or not? All right, there we go. And for you all that have attended the call, wrote a book called Raise, the book on funds and syndications. Not quite ready yet, but when it ships, if you scan this code and you're on the list, you'll get a free copy before it actually goes on sale, and then you'll have to purchase it. All right. Also, book a call with us and get a free legal consultation with Raise Law. And now we'll open it up to questions. Marcin?
Yeah, well done. Appreciate you doing that. You're covering a lot of, it's what I appreciate about you doing is kind of going back to first principles on why things exist. As an example of that, PPM, everybody pre being in this business for a while, they think the PPM is like a pain in the butt sometimes. It's like, no, that thing is actually your insurance policy. You're literally buying that in case investors have, short-term or long-term memory loss, right? Like they forget the terms, and ultimately having that PPM there to lay everything out cleanly. So I'm glad you brought that up because it's really important to actually have that in place. Also, investors that have invested in a lot of syndications, if you don't have a PPM, they're kind of weird about it. So I appreciate you obviously bringing that up. Also, the just the differences between syndicating and funds and funds of funds. I know your firm, you guys work with a lot of different clients, and we'll do see if there's some questions in the chat here from anybody. But in your mind, Seth, is there like a right pivot point for when somebody should go from like syndicating perpetually to maybe doing the fund or fund to fund thing? Like, what are your thoughts on that?
Yeah, I mean, I think it comes down to comfort level and your business too. Again, like you should, in my opinion, you should always start out with syndication. If you're asking yourself, this is my first raise, I've got one asset I'm looking at because typically that's what's happening. But do I just start a fund and start trying to raise some capital into? Like syndication is always first. It's just so much easier to raise capital into a syndication than a fund. It's just a much more, again, transparent, easy way for an investor to get involved. They can see the asset, they know where their money's going, they can underwrite the deal. As opposed to a fund, there's just a lot more trust involved. I see a lot of operators say, okay, I'm going to do some syndications. They have a lot of success. And then they switch to a fund and they do that for a while. And then they come back to syndications because they just like the simplicity. They like the asset protection. They like that it's easier to raise for. So, I mean, you'll see, both worlds. I don't know if there's kind of a true delineation there between kind of here's where you get to that point. And you say, I'm going to do a fund from here on out. I would say that if you can raise into a fund, though, if you can raise into a fund and raise a lot of money, that's probably where you want to end up because you just have a lot more flexibility, right? Like if you can raise $20 million, $50 million and put it into a fund, and then you can go to a seller and say, I've already got this dry powder ready and waiting for me, then that's a powerful position to be in from a negotiation standpoint. And that can get you far. So if you need to close fast and you want some leverage in the negotiations, a fund fund has many more advantages.
Yeah, no, I appreciate that. And my preference is always doing a fund model just because of exactly that methodology. But and the last deal we did, we literally got 5 million off the purchase price because we were like, here's the bank account. And it just changes the dynamics
Yep.
altogether. But you're right, it does take a different level of skill and a different type of conversation to be able to do that with potential investors. And I agree with you for the most part, for most people starting out syndications for the first. And there's people that, by the way, that built my mentor, Ken McElroy, at 2 billion AUM. They still syndicate. Like they do everything syndication, right? So there's no right or wrong way to do it. I think is the point. But to your point, yeah, if you're doing your first, second, third, or whatever deal, syndication is typically a much easier way to go about doing it. So I'm just looking in the chat. If any of you guys have any, I don't know if you guys are able to type in your comments, but if you guys have any actual questions or comments for Seth, we can definitely take them now. It's obviously a privilege to have Seth here answering things live. Another question I'll ask you, Seth, is while people decide if they want to ask some questions, is um, when somebody is building their syndication, what are some of the most common mistakes that you see them making in terms of actually putting the deal together where they end up having to go back and like rewrite things or change things, or what are some like the most common issues or mistakes that guys make?
I would say overcomplication.
Okay.
They become part of, a mastermind like this one, or they see YouTube videos and they see like all the things that you can do, right? Like we kind of
Right.
open up those possibilities. We're like, well, we can do these 10 different fees, or we can do five different membership classes, or we can incentivize investors to invest more by doing, these different investment minimums. Those are all great tools to use, and you should know that they exist, but you shouldn't overuse them. Investors that get confused don't invest. If you can't explain it very simply, kind of what happens to their investment dollars or what options are best for them, then they get confused and they move on. So don't offer 10 different ways to get involved. Offer two, offer three, offer one. A lot of times we'll go into something and we'll draft this very complex waterfall structure multiple
Yeah, you're
membership
right.
classes, and it just
Yeah,
turns
yeah.
into a
And then they
mess.
have
And
IRR up to this, and then
right,
IRR up to that,
yep,
and then da 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 da, right? And then how do you explain
yep,
that to somebody, right?
right.
So,
You explain that to investors, and maybe you understand it, but most of
yeah,
them don't, and they're just like, I don't know. Let me get back to you, right? Let me circle back.
yeah, yeah, yeah. No, that's a really, really good, good framework. Yeah, because people like they'll look at somebody, who's raising like a couple $100 million, and maybe they've got some institutional guys in the stack or whatever it is. And then yeah, they have the IRR waterfalls where it's like after 8% it's this, after 12% it's this, after 15, and then you like, and it just like retail investors, how would you explain this? That's a really good one. Question here from Alan was, and I don't know if there's a, I'll ask you the question. Typical preferred return and sure. Are there any typical boilerplates, or is it always asset or strategy driven
Yeah,
in
I
your
mean it's always asset and strategy driven, right? But I would just say, from a and you don't see a lot of these deals anymore, but your typical kind of value add multifamily play, 100-unit apartment complex where you're going in and doing some renovations and then raising the rent 100 or $200 a month. Again, you don't see those deals that often anymore. They're starting to come back around, but you might see that 6 to 8% pref, something like that, a 70-30 split, and maybe those higher investors might be incentivized with an 80-20 split.
okay. And then another question here because we got 2 more minutes here. Sean asked, can you post on your personal LinkedIn page for a 506B raise without concern of violations? Not an ad, a post theoretically to your network.
It would have to be a very closed environment. I would say the answer is probably no. If you're posting that to people, because think about who are your LinkedIn contacts. If you have a personal relationship with every one of your LinkedIn contacts, and then that post only goes to them, and that post does not go to any strangers, then I guess the answer would be yes, you could do it, but I don't think that you're going to be able to produce that closed environment and be able to say that I have a personal relationship with every single one of my LinkedIn contacts.
Yeah, it'd be a hard bar that'd be a hard thing to prove, and you want to keep it simple, right?
Another example that could be like, I would think like a more closed environment. Maybe you have a Facebook group of people that you only let in that you have a relationship with, and then you could post it to that group. But as far
Right,
as just on general social media, it'd be really difficult to control.
right. Alan asked, what is the typical cost to prepare a syndication or your first syndication?
Yeah, it can be. So for us at Raise Law, we'll do it anywhere from $12,500 at the very least, up to about $20,000. So it's going to be in that range depending on complexity. I would say we're on the lower end. When I worked at DLA Piper, which is the third largest law firm in the world, and this was 7 years ago, we used to charge $75,000 for the same documents, and then we would charge $1,000 an hour for any kind of extraneous thing. So anything on top of that. So every bill would be well over $100,000.
Yeah, no, I've paid plenty of those bills for funds and syndications before, so I'm familiar with it. He's very much telling you guys what it is because that's typically what those firms charge. Rand asked, what are things to watch as someone who wants to do both funds of funds aggregation for other operators and raise for ourselves as an operator?
Yeah, I mean, if you want to put those all in the same vehicle, I mean, obviously that's not a syndication, that's a fund. A fund can operate as both of those simultaneously. So you can buy assets yourself and be the operator of certain assets and put those into the same fund that you also allocate capital to other people's syndications or deals. You have to be really careful there. We do trigger a lot of different securities laws by doing that, but you can put those all in the same fund if you want to.
Excellent. Thank you, Seth. This has been really, really informative. And I like how you broke it down to first principles and then started building it all back up because it's really easy to get confused with all the PPMs and operating agreements and all this other stuff and JVs and GPs and everything in between. Guys, go ahead and book a call with Seth and his team at Raise Law there. We are at time, but again, Seth is part of the the sponsorship team here with M1 at our events. So they were at the last workshop. Hopefully, we'll see you guys at the next one and the next one after that. So if you guys have questions, obviously reach out, book a call, and yeah, Seth, I appreciate you taking the time.
Thanks, everyone. Appreciate you.
All right, see ya. Take care.
See ya.